Ladies and gentlemen, welcome back to the Indie Zone. On April 18th, 2025. Judge Hippler rendered a long written order memorializing the verbal proclamations he made from the bench at the April 9th, 2025 motions in limine oral argument. This is order memorializing oral rulings on motions in limine. There are multiple of them. We're going to circle back and provide you with further details later, but what the rulings are as follows. Defendant's motion in limine number 1 regarding inflammatory evidence. The court had denied this motion. However, because this was a particularly horrific scene and there will be exceptionally graphic depictions, prior to seeking the admission of this evidence, the state is required to provide copies to the defense, and if defense believes the evidence is cumulative, unnecessary, or otherwise prejudicial, he can seek to take the matter up outside the presence of the jury, so objections can be made at trial. 2, defendant's motion in limine number 3 regarding use of the term M. This is denied as unnecessary. The state acknowledges it would be improper to refer to defendant as the M, the unaliver, other than stating what the allegations are, and has no plans to do so or otherwise elicit similar testimony. Next, defense's motion in limine number 4, use of the terms psycho or socio-infilopathic. Defense moved to exclude any reference of these terms at trial, arguing it is unfairly prejudicial and improper. This is granted. Next, the motion in limine regarding improper DP comments. State moves to preclude defense counsel from making what it calls improper comments about the DP, specifically that the state is attempting to unalive the defendant. The court trusts defense counsel will comport themselves accordingly, and the motion is denied as unnecessary. The defendant's motion in limine number 8, unnoticed 404B evidence. Defendant moves in limine to exclude any 404B evidence that has not already been noticed by the state, which at this point is only defendant's pre-homicide traffic stop. This was the stop that occurred in Moscow in August of 2022. At this time, the motion is denied because the court is unwilling at this point to preclude the state from filing a 404B notice in the future if it determines its evidence is encompassed by the rule. Next, defendant's motion in limine 10 regarding an improper expert testimony as to middlemen. Defendant's motion in limine 11 regarding excluding IgG evidence. State's motion in limine regarding IgG genetic genealogy. Both parties moved to exclude evidence of law enforcement's and IgG testing in this case, but for entirely different reasons. Given the parties' agreement to not present any IgG evidence, these reasons need not be discussed, given the bottom line agreement, and the court grants the motion. The state has indicated it will provide evidence through Detective Payne, and defendant's name was revealed to law enforcement through a tip. The court, therefore, has ruled in this manner. The parties are directed to jointly craft a jury instruction advising the jurors to not concern themselves with the source or the nature of the tip. Next, defendant's motion in limine 13 regarding conditions as aggravator. Defense moves to prevent the state from using defendant's diagnosis of autism spectrum disorder and the characterization of his ASD as an aggravating factor at the penalty phase of trial. This is not the case in chief. This is the penalty phase. The motion is granted in part only. At this point, the court will preclude the state from arguing or presenting evidence of defendant's ASD diagnosis as an aggravator, but it is not in a position to rule on whether any particular evidence must be excluded on the grounds that it evidences a symptom of defendant's ASD. Next, state's motion in limine regarding alternative perpetrator evidence. State seeks an order prohibiting defendants from offering alternative perpetrator evidence without first making a showing that such evidence is relevant and admissible under the rules of evidence. These rules govern the standard of admissibility for alternative perpetrator evidence. This is a defense, ladies and gentlemen, citing to State versus Meister. Bottom line here, to avoid any undue delay at trial, the defendants must present offers of proof of any alternative defendants no later than May 14th, 2025, so that the matter can be addressed at the pretrial conference. The court will reserve ruling on the motion. Next, defendant's motion in limine regarding statistical analysis. Defendant moves in limine to exclude any misleading comments about the meaning of a, quote, likelihood ratio for DNA purposes, and specifically, defendant seeks to avoid attempts to define likelihood ratio through a comparison to the world population. The state agrees this type of comparison is inappropriate. The court grants defendant's motion so far as it applies to the question asked by the prosecutor at the grand jury proceedings, which both sides agree was not proper. However, the court will not dictate how the question is to be asked at trial. If defendant believes there is a similar misrepresentation as to the likelihood ratio at trial, he can object at that time. Next, defendant's motion in limine regarding inconclusive data. Defendant moves in limine to limit expert testimony about the Idaho State Police Forensic Lab's statistical analysis of a swab taken from the fingernail clippings of Madison Moken. This is item Q13-I. Testing reveals a likelihood ratio on the inconclusive range as to whether defendant was a potential contributor to the DNA mixture. And at this time, the motion is denied as moot because the court has said here, the state indicates it will not offer the results of Q13-1 as inculpatory evidence, which defendant agrees renders his motion moot. That means that there's really nothing more here for the court to rule upon. However, if the state changes course with regard to this evidence, it must first raise the matter with the court outside the presence of the jury so the anticipated testimony regarding the meaning of inconclusive can be discussed. At this time, however, motion is denied as moot. Next, defendant's motion in limine number 9, excluding Amazon click activity evidence at trial. Defendant moves to exclude any evidence of defendant's Amazon purchase history or click activity on the grounds that it is out of context, incomplete, and unfairly prejudicial. This evidence will be presented by the state through Shane Cox and Michael Douglas, who will testify simply to what the documentary evidence states, all of which was provided to defendants in discovery. Defendant is free to challenge this evidence through cross-examination and establish through their expert, Mr. Howell, why more information is needed to reach the conclusion that defendant made the purchase or clicks. However, it is not a basis for exclusion, thus the motion is denied. The Amazon evidence is getting in. Next, state's motion in limine regarding AT&T timing advance records. The state moves in limine to prevent the defense from making any reference to the absence of AT&T timing advance records related to defendant's cell phone. The state contends it never received such records from AT&T in response to its subpoena, and therefore any statements made by defendant that the records could or should have been provided to defendant should not be allowed, as it mischaracterizes the evidence, will mislead the jury, waste time, and cause undue delay. In support, the state provides certificates of authenticity from AT&T for each of the 2 warrants. The court here has granted state's motion except as qualified regarding the very brief voir dire outside the presence of the jury. State's motion in limine regarding self-authentication of records and reliance on IRE, various rules of evidence here, 803, 902, and or 803 subsection 24. State moves in limine to permit the admission of approximately 60 exhibits pursuant to the Idaho rules of evidence without having, ladies and gentlemen, to have someone, for example, some of this evidence, corner club video or video from Linda Lane Apartments, having someone come into court and to authenticate that they are true and correct copies. The court has found that the court will require, after proper notice is given under IRE 90211, the parties are to meet and confer regarding self-authentication and any objections defendants may have to specific exhibits prior to raising the issue with the court. Court's ruling on the motion is reserved. Next, motion in limine regarding admissibility of a demonstrative evidence. This is the state seeks permission to use not scale 3D model 1122 King Road residence as a demonstrative exhibit. The court has granted this motion. State's motion in limine regarding alibi. State's moves to preclude defendant from offering any evidence in support of an alibi Other than from the defendant himself, the basis for the state's motion is defendant's failure to comply with the notice requirements governing alibi evidence. The court then looks at 19.5.19.1 and ICR 12.1. If requested by the state during discovery, a defendant intending to offer the alibi must file a notice listing the specific place or places which the defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses upon whom he intends to establish such alibi. The court here will not categorically preclude defendant at this point from offering alibi evidence at trial. Whether or not, if defendant does unearth alibi evidence, it is his obligation to immediately make the state and the court aware of it. At this point, the court can apply the Juarez standard. Excluding it at this time is premature and therefore the motion is denied. However, subject to being re-raised if defendant does disclose alibi evidence. However, at this point, defendant has not provided an alibi, partial or otherwise. So there goes the PSI partial alibi out the window, ladies and gentlemen, as we had predicted. State's 404B, notice prior traffic stop. The state moves under IRE 404B for the admission of defendant's August 21st, 2022 traffic stop in Moscow, during which time he was stopped for speeding and issued a citation for failing to wear a seat belt. The court has decided to allow some of this testimony in. Thus, the motion is granted with the noted redactions. And there's certain redactions that need to be made that we will go over in a subsequent presentation. Until next time, this is Kathy. Thank you for joining us here today.